Hi Sarah, Michael, I'm Chichi Lengarouse. This video is to advise you of the Australian statutory and common law surrounding your trademark, the trademarking process, and yeah, going through how to obtain it, maintain, and how it protects. Now, fortunately and beautifully for both of you, you can apply for the registration of a trademark, to trademark something that's already been used or that you intended to use under Section 27(1) of the Trademarks Act, and also established by Justice Dixon in Shell Co. and Rom and Haas 1949, which is perfect for you guys. So yeah, let's get into it. So under the Trademarks Act 1999, trademark holders can apply for a registered trademark with IP Australia, wherein a trademark examiner will assess it for protection under this act. When registering a business, company, or domain name, this does not immediately give exclusive rights as registered IP does. So this means it is important to remember to register a business, company, or domain name as soon as possible, so you do not automatically have the right to use the name as a trademark. So the process of actually obtaining your trademark. So the trademarking journey begins in Part 4, Section 27 of the Trademarks Act, with all the requirements and regulations kind of outlined there. What this looks like in practice is first determining the trademark you want to protect. That would be the logo symbol and then the words themselves, and then ensuring it has not already been trademarked. Then the application is filled in and under Section 31, examined. By Section 33, the registrar will accept or reject the application. Now please note that if it is accepted, it is not immediately registered. Then we go on to the next step, which is called the advertisement period, which is also known as the period of opposition. In this 2-month period, anyone in the country or the world can oppose the trademark. If the trademark is unopposed in those 2 months, the applicant proceeds to registration. Now, even after registration, an applicant has to be wary, as there exists a number of post-registration actions open to the public to remove the trademark from the register. But even so, the rights under Section 20 of the Act granted to a registered act may be enjoyed. So most importantly, when you can initiate infringement actions against those infringing on your trademarks. Now, a downfall of obtaining a trademark is that it is a long and arduous journey. The trademark registration process takes a minimum of 7 months, but more realistically, stretching longer for up to 2 years. Costs begin at $250 minimum, but go up to $600, depending on the class, with additional fees here and there, fees for amendments, things like that. While this is not a lot to spend for a company, it can be a lot for a small business or self-employed individuals. This rigorous process, though, is not without reason and is ultimately very fruitful and ensures that you can rely on this legislation. Now, to determine if this trademark already exists, we need to investigate online via IP Australia's Australian trademark search. So as highlighted here on the slide, the term eco-green safe tech has not been trademarked, meaning it is viable for trademarking. And that includes no spaces eco-green safe tech. This also includes eco-green-safe-tech. And so they are viable options to trademark, but please do note that eco-green or eco-green, as well as safe tech and safe-tech, have been trademarked and so will not be able to be used in any iteration lest we risk, trademark infringement, things like that. Now, in terms of your image, as seen on the top in the left there were very few similarities with your logo and any other logos currently trademarked. The most similar is the ACT Environment and Sustainable Development Directorate, which in itself is currently removed from the site as renewal was not paid. As you can see, that's the one next to yours on the slide. This doesn't mean that it will never be trademarked again, but we should be safe, as whilst the topic of your company with this other company are similar, your logo possesses green and orange, 3-dimensional images, and 2 leaves rather than 1, differentiating yourself from the ATC logo for their Sustainable Development Directorate, and also the Matter Energy Group, which also has a cog thing going on, but also, once again, no colors that really replicate what you guys are doing. So yeah, it should be well and good to copyright both the words and the image and the logo. Now, the classes to consider applying for when you make your application are listed below. So I've got Class 7, which is powered drive machines and tools. Now, you guys have an interest in making wind turbines and solar panels, and so this might be an important class for you to apply. Another is Class 16, which is paper, cardboard, printed matters such as books, pamphlets, and brochures. And so anything that you're printing, such as a pamphlet to give out to people who are interested, or cards or things like that, it is just a very safe thing to do, is to have that class satisfied as well. Now, you also mentioned making sustainable recycled furniture, and so under Class 20, that one will have to be satisfied. That way you can do your rework chairs, tables, cabinets, whatever strikes your fancy without getting in trouble or getting anything copied, and people knowing where their furniture is from. And same goes for Class 25, which is clothing and footwear and headwear. So all these accessories, all these like bags and all this clothing that you want with your logo on it will be safe and satisfied. Now, yeah, it is worth recognizing that it is a extra $400 for every class, but it is well worth the protection that it achieves when doing that. A benefit in maintaining a trademark is its ability to be renewed. Not all areas under IP law are renewable, but Sections 75 through to 80 of the Act stipulate the ability to renew your trademark. Importantly, under Section 77, it states that the trademark protection lasts for 10 years, and after this time lapses, it must be renewed. When renewed online, the fee is currently $400. Another benefit is that Australia is also party to the International Trademark Protocol, the Madrid Protocol, which allows for registration of international trademarks covering multiple countries, allowing a process for business to protect their marks globally. So if you wanted to expand internationally, there is an avenue for that. Even the best maintenance, however, can go amiss. Though whilst trademarks can be renewed indefinitely, they are subject to cancellation and removal provisions, which apply if the mark is not being used or if it becomes generic. While daunting, trademark is an economic tort at its heart, and this prevents individuals from sitting on unused capital that trade possesses. The classic situation encountered is infringement. Trademarks are protected from infringement under Section 120 of the Trademarks Act, which is satisfied if someone in a similar industry to you is using a substantially identical or deceptively similar logo, shape, or colour to your product. Additional to this, your trademark must also be well known in Australia. That's how you get people for infringement. So if anyone is kind of copying your product, you can get them for that. Another situation where newfound trademark holders may encounter, depending on the success of your trademark, is other companies or products replicating your trademark so as to exploit the reputation of your particular trademark. This specifically concerns the tort of passing off. This tort prevents the unauthorized use of trademarks and other trade indicia that have an acquired reputation in the market, and helps misrepresentation as well as helping to protect aspects of reputation not covered by the Trademarks Act. In the situation of defending yourself against someone infringing on your trademark like this, the classic trinity established by Reckitt and Coleman Products and Borden, 1990, would require establishment. So this includes, first, the existence of your product having a reputation in the relevant market. Secondly, a misrepresentation by the defendant, where they intentionally mislead consumers. And finally, the existence of actual damage to you as a plaintiff, maybe in sales, things like that. So this tort differentiates slightly when compared with trademarks, as formal registration is not needed for it to apply, as the scope can protect aspects of goodwill not covered by the Trademarks Act, such as misrepresentation of quality or sponsorship. And in addition, the burden of proof to prove this in reference to reputation and damage is generally higher than in trademarks infringement claims. Even so, this is viable for trademarks issues that have already been registered, and also relating to replication, things like that. Whilst trademarking can be fickle and confusing, heavy on administration, and at times costly, it is this way due to its extensive protection and justice. Trademark is emblematic of a cohesive system that is supported through a rich history of common law and statutory law, as well as tort law. This ensures your trademark is protected in as many facets as possible. So thank you. I will attach the relevant drafting of your trademark application, and we'll go from there. Thank you.